You would not have intermarriage. You would have people living on the edges, not allowed to share water, not allowed to eat, etc. together. And they looked at the phrase that they used to use then until it was dropped in 1935. The depressed classes.
Editorial mistakes can sometimes cause very grave blunders.
Correct. Correct.
In fact, when we wrote I wrote the seven-judge judgment on the Arbitration Act.
Yes.
It was an editorial blunder in one of the private publications which was handed over to the bench.
Oh.
Which pointed out that a particular provision was brought into force when it was exactly to the contrary.
Oh, it wasn't brought into force. Well, that's very risky, Manoj. 7 judges we should.
And it was.
Where does that schedule come from? It comes from the Government of India Act 1935, and there's a background behind it. It starts with the census in 1891. I'll briefly touch upon that. All of that is in volume 4B. The second.
In this video, you will watch arguments in Honorable Supreme Court of India with related to SC/ST subclassification quota. As I already in part first of this video, I elaborated what is the background of this case, why this case is before the 7 judges bench, as I already discussed that. This is the 5th part of argument. The videos will be uploaded in part wise. For that, please subscribe my channel and you will get update related to Supreme Court arguments and on legal topics.
Briefly, this will also briefly touch upon that question that fell from the bench yesterday about why tribes, the word is used while defining scheduled castes.
In 341 also.
Yes. Why is it used there as well as in 366? In both places, scheduled castes are including tribes. Why does that happen? The second, Manoj, is that the constitution and its approach towards scheduled castes and scheduled tribes. You'll find that it was a very, very important and integral part of our constitution making, starting from the Pune Pact, starting from many other big leaders, both from the Dalit community and outside, who were responsible for ensuring that many provisions of the constitution were infused with taking steps. Article 15, which has provisions which come from the Pune Pact, Article 17 and its abolition, exploitation provisions in 23. All of these, along with 15, 16, yes, of course, that's what we keep dealing with. But we must draw a small distinction between 15 and 16, which are provisions which are not automatic, which don't immediately give a right to a member of the backward community. It is for the state to make a law under 15, 16 if it so wishes. So 15, 16 are enabling provisions. 330, 332 and the provisions dealing with municipalities and panchayats give them a right. So how that started and that context under the constitution will perhaps help, I think, this bench in looking at the context in which we are arguing this case. Because in my view, at least my submission is that this subclassification is to be done at the end when the enabling provision is being activated. It is at that end that you decide while dealing only with 15, 16. That subclassification cannot be, and I think it came in the discussions earlier today, in 330, 332, etc. That can't be done. It's on 15 and 16.
Or the Panchayat Raj and municipalities.
Yes, or panchayats or municipalities. That's the second limb of the submission.
Yes.
The third, it's been touched upon by Mr. Sibal. I won't spend too much time on it. That error in Chinnaya, while looking at the Thomas paragraph of Justice Krishna, in fact, I'll make this point right away. It's just that this is an editorial intervention, an unnecessary editorial intervention in the SEC volume, which has caused this confusion. What exactly happened is in N.M. Thomas, Justice Krishnaiyer uses the word they, T-H-E-Y. He uses that to refer to the various groups, etc., who are the Dalit community. He says that they aren't part of the Hindu groups. Unfortunately, when the editor published in SEC this judgment, within brackets, it put SIC, sick, there, T-H-E-I-R. Now that there is treated by Justice Hegde in Chinnaya to mean, therefore, a complete homogeneous group. They and there made a big difference. I'm just making this submission. The Lordship may see those two paragraphs, but I don't want to spend too much time on that.
Right.
And finally, there are a few questions that fell from your Lordships yesterday. I just want to address each of them. I think there were some doubts that your Lordships had. So I'll just do that briefly. If your Lordships, the first main limb is going to be the first two. 4B, volume 4B, B for Bombay. of the compilation. And I'll quickly go through that.
Editorial mistakes can sometimes cause very grave blunders.
Correct, correct.
In fact, when we wrote I wrote the seven-judge judgment on the Arbitration Act.
Yes.
It was an editorial blunder in one of the private publications which was handed over to the bench.
Oh.
Which pointed out that a particular provision was brought into force when it was exactly to the contrary.
Oh, it wasn't brought into force. Okay. Well, that's very risky, Manoj. 7 judges we should.
And it was, so we noticed that and corrected the error in 7 judges.
Good. Well, so if I can trouble your lordships with volume 4B. 4B for bomb. I'm sorry. Yes. The first page, that's the census report of 1891. The lordships have that? Census, that's page 2 PDF as well as running page.
No.
No.
That is Dr. Ambedkar Foundation, that is writings and speeches.
Volume 4B for Bombay? 4B?
4B.
Dr. Asa Ambedkar writing and speeches, chronology of events.
What's the nodal council?
No, I've been told.
No.
No, we have downloaded it as Roman. It's Roman 4B.
Roman 4B.
It's for others also. It's census report. I'm sure. Sorry if there's
Roman 4B.
Huh? The one your lordships are referring to is 4A.
4B.
Oh, 4B. Oh, I'm sorry. Then would your lordship check 4A? Because we have all been told that it's 4.
Also has some reference to Norway incident which Mr. Faraz yesterday mentioned.
Okay. I'm sorry.
4A has Constituent Assembly debates, etc., etc. The tyranny of merit, Michael Sandel.
Let me check which volume this is.
Meritocracy trap.
Huh? Could you
I can wait in.
Just a minute. 4C, 4D. Sorry. 4B. Oh, this is something else. What do you say? No, let it be. I'll just address them. Look, it's filed a volume. Refer to compilation. It's not there. But no, we checked with the nodal council. He said it's been uploaded. If it's not, I'll just anyway address your lordships. Then it's going. We'll go right now. Okay. But they're just uploading it. I'll just address your lordship. I don't want to take time. I'll just briefly tell your lordship what it is. There is an 1891 census report. It was the first census report. Now that census report went into a detailed enumeration. At that point of time, what they did is they went through occupations, because throughout the 19th century, the British had come up with many reformist processes from their end as far as the Hindu community largely was concerned. Your lordships know everything with reference to Bentinck's reforms, etc. But towards this end, they wanted to find out what the various occupations were, because they found that within the large Indian communities, you would not have intermarriage, you would have people living on the edges, not allowed to share water, not allowed to eat, etc. together. And they looked at the various occupations, because many groups were being excluded completely from the occupations. So occupation-based census is this one of 1891. And this provides for the manner of the enumeration, the classification of the occupation, and they specifically say that with reference to these, what they came to refer to as depressed classes, that's the phrase that they used to use then until it was dropped in 1935, the depressed classes, they said that there were many, even within the Rajputs and the Jats, they didn't look at them as castes, they looked at them as tribes. That is where, Manoj, this notion of tribes for the purposes of the depressed classes. We are not right now talking about the scheduled tribes, scheduled castes. With reference to them, they refer to them as tribes. And they mention community-wise the various groups which are dealt with, which includes 10 minutes. The various tribes. And they And they divide them into various classes. Class Roman 7. Class 7 are known as the menials. Those are the ones today who have been come to be described as the scheduled caste. This is stage 1, 1891. The next one is 1930, which is the Indian Statutory Commission, which goes in detail into these depressed classes. The phrase depressed classes eventually came from a report of 1918, which became a part of the Montague-Chelmsford reforms. But they refer to, they use the phrase, employ the phrase depressed classes. They look at these statistics from previously and say nearly 20% of the population belong to these classes. They say that these classes are partly functional and partly tribal, and they mention the various types of disabilities that these groups have been suffering over a period of time. The 1931 census is the third in this sequence, and it was carried out by a famous anthropologist at that time, Mr. Hutton. And he says, for the first time, he refers to primitive tribes. This is where the concept of scheduled tribes come in. They say that there are many tribes because the exploration of India for the British census takers was taking time. So they reached Nagaland, Arunachal, etc., and discovered many tribes which are nomadic or in jungles and forests, etc. And they refer to them as primitive tribes who haven't really come in contact too much with society. And they refer to them, 1931 is the first time that you find that there are these primitive tribes as well. This is for the purpose of the identification. And they shift in 1931 from depressed to referring to them as the ones formerly known as untouchables, and say that we shall refer to them as the scheduled caste. Now, the reason why scheduled caste is that in Government of India Act 1935, they eventually laid down that for representation in the federal legislature, there would be a first schedule to the Government of India Act, which would provide how the various communities were going to be represented. Now that, I think they're just transferring it. That is the one thing I'd like your lordships to see. Because all these communities that you find, where did in 1950 did the president suddenly get this list? He got